we are ready for our next set of speakers. We are going to have a panel about the intersection of cybersecurity and law. We have brought three great panelists that I have a number of interactions with in the past. One of them I hosted a podcast with. Other two have been guests on that same podcast. Whitney McCollum, Kevin Powers, and Erik Weinick. Welcome to the panel. Please take a second to introduce yourselves. We'll start from the top down. Whitney McCollum.
Hi, everyone. Thanks so much for having us, Jerich. Great to see you again. I'm Whitney McCollum. I'm a partner at K&L Gates. We're a global law firm. I'm based in our Seattle and San Francisco office. I'm data privacy, cybersecurity, and technology.
Thank you, Whitney. Kevin Powers.
Sure. Hi, everyone. I'm Professor Kevin Powers. I'm the founder and director of the graduate program in cybersecurity policy and governance at Boston College, where I teach over at Boston College Law School and within the Carroll School of Management. Also, I am a research affiliate and lecturer over at MIT in the Sloan School of Management, where I teach executive education focused on cybersecurity for board of directors.
Thank you, Kevin. And last but not least, Erik.
Thanks, Jerich. Nice to be here. Thanks for having me again. Erik Weinick, co-head of the Privacy, Cybersecurity, and Digital Assets Group here at Otterbourg. We're a smaller firm than K&L. We're based here in New York. We represent all manner of clients from large financial institutions to small entrepreneurs. I focus my work in that area as well as in winding down companies that have been involved in financial frauds. Excited to be here today to talk about the intersection between law and cyber.
Well, thank all three of you guys for joining, guys and gal, for joining. We are going to hop right in. I have a number of questions. But for all of you out there, if there are any questions that you guys have, please put them in the Slack channel. I'll be happy to get to them. We should be leaving enough time for that, but lawyers can be long-winded, so let's just find out if that's actually true. First and foremost, why is it important for CISOs to have relationships with both internal and external counsel? A lot of them have somewhat of a relationship with internal counsel, but I meet very few that actually know who their external counsel is. Let's start with you, Whitney.
Thanks, Jerich. So I've been both internal and external counsel. Jerich and I were working together when I was in-house and he was the CISO. So I'm very passionate about this, but internal counsel is your partner as the CISO. They are there to assess risk to the company and to mitigate that risk. And that's what you are there to do as well. Your job is to assess cyber risk, mitigate cyber risk, escalate. You have eyes, ears, and voices in different parts of the company and you serve different roles, but partnering together, you are much stronger. And so your role is to understand cyber threats internally and externally and how well the company has a handle on that risk and what you can do to mitigate it. The lawyer's job is to know the laws that the company has to comply with and to help prioritize the risk with respect to compliance with those laws. So how this works in practice is you understand there's threats to the company based on the type of information you have, where you're located, the type of technology you have. You know ways to mitigate that risk. It might cost money, it might cost time, it might cost resources. You and the lawyer work together to get that voice up to the executives, to the board, so they understand here are the risks that we're facing. And the risks can be cyber risks, but they also can be legal and compliance risk, and they can be publicity risks. The FTC in the US is incredibly active right now, and your lawyer is going to be the one that says, hey, this is really important because we have a legal risk. There is investigations, there's lawsuits, the scary things that will get executives to say, oh, we really have to take this seriously.
Yeah, that's a great point. And I have found that no matter how much weight the CISO has, the lawyers have a little bit more. And so every once in a while, the lawyers can be that arm to push something forward if necessary. So thank you for that, Whitney. Let's jump over to you, Kevin.
Sure. My thought on this is it depends. I think if you're a big enough company, that you should definitely have a relationship with your internal counsel. right? That's for sure. Because cybersecurity has, Whitney, I could really just say what she said, but, since we have a panel, I'll follow up with my thoughts as well. You really look at cybersecurity, it's not a tech issue. We all recognize that, right? It's a business financial risk management issue. And as such, you need to have the CISO having those relationships with the lawyers, but also not just the lawyers, with HR, with the business unit, right? The risk managers, right? Throughout the whole enterprise. So when you look at what the general counsel is working with, internal counsel, with the CISO, it's really helping them. When you set up a framework, it's not just on tech, it's not just on risk. There's a lot of regulatory ramifications that are involved, and they have to match up with the different business sectors you work in, whatever sector, or cross sectors as well. So having that relationship is very important. I think for a bigger company, you're not going to have that much of a relationship with outside counsel unless you're doing tabletop exercises or they're coming in to help you, but that's going to be via internal counsel. Now you get to the CISO who's at a mid-sized company, they're probably not going to have any internal counsel at all. And I think that's where Whitney and her team, and Erik as well, you're working with outside counsel to take care of all those issues that you don't have any legal counsel internally to help you with.
I love it. Erik, you may have stole some of your thunder, but
no, I think I can run with a little bit of what Kevin touched on. Just as at a high level, lawyers in general, our job is to make your job easier, and recognizing the type of client that you have and the size, as Kevin discussed, it's a small company, a medium-sized organization, a large institution, allows the lawyers, whether they're in-house or external, to tailor the solutions that are appropriate for that organization. And you can only do that. Well, you can only do that well if you do it in advance. You can do it on the fly in an emergency, but you're not going to be as effective if you're responding to an incident for the first time with people that you've just met, that you don't have a pre-existing relationship with, that are just starting to learn your organization, learn what's important to you, learn what the priorities are. And so the more you can do in advance to learn about each other, to, have internal counsel or external counsel that's got a list, not just of these are the people in the CISO's department, these are the people in HR, but these are the business partners that we've obligated ourselves contractually to notify in the event of an incident. These are the regulators that we work hand in hand with in the overall course of our business that we need to be in touch with, or that are there to help us. Those are all of the things that internal and external counsel can provide. And the more firmly established that relationship is in advance, the more, to Whitney's point, you can mitigate, the more you can respond to an incident.
Completely agree. And I had one more plug that I was waiting for you guys to throw in. External counsel can specialize in cybersecurity. Not all internal counsels have the skill set to even handle cybersecurity questions. There's so many specialties: immigration law, corporate law, tax law, the list goes on, and cyber is in that list. And until it's something that's forced curriculum in law schools, you're not always going to have internal legal teams that understand the nuances and how it all works, or even privacy for that matter. So I'm gonna keep.
I'll make another plug. We have 4 courses on such at Boston College Law School that I teach.
Good plug. Good plug. Someone is Googling that right now.
Send me some of those students.
So speaking of the fact that legal is definitely an organization that cyber teams need to work with, what do you find that people misunderstand about the role that legal can actually play in the development or execution of a cyber strategy? I'll keep it with you, Erik.
Yeah, I mean, I think that oftentimes we fulfill the stereotype when we're not being careful, but they see lawyers as a roadblock to getting a business deal done. You mentioned privacy. Most contracts from any significant sized company these days come with privacy provisions and sections, and cybersecurity provisions and sections, and the lawyers can help the business folks, the CISO, everyone that's involved with identifying what is important in those both to the business partner and to the organization itself. And we're there to get the deal done and help the business fulfill its core business function, not to be a roadblock, but we're there also to provide guidance and to pump the brakes when it's necessary, because a business person might be in a rush, say, oh, come on, I want to close this deal, it's month end. That's never going to happen. It's not important. And when you point out to them the significance of an obligation that they may be undertaking, it can be eye-opening. Or, if you're on the reverse side of it, insisting that a business partner undertake an information audit, or insist that they have adequate cybersecurity insurance with you as a named beneficiary, you really demonstrate your value as a member of the team, and that you're not a hindrance to getting a business goal accomplished.
Completely agree. I won't even add on to that. Whitney, what are your thoughts?
So I have 3 common reasons, really maybe 4. One is they won't understand. 2 is it's not a legal issue. The 3rd is lawyers will tell them no, which I think, Erik, you addressed well. And 4 is they're too busy and shouldn't be bothered. I think 4 kind of goes with it's not a legal issue. In talking to that role of partnership, whether it's in internal or external counsel, you want to understand the roles and the importance of bringing someone in early, thinking about your internal counsel as your partner, get them in earlier. Those contract reviews can be really painful. I know we often get those agreements like 2 days before, and it's like, hey, hold on, they're actually not protecting the data that's really valuable here. This isn't a last minute decision. But when I get pulled in, early in the discussions, even before there's agreement, I'm like, all right, let's talk about the data. How much is it going to matter? How are we going to protect it? And so really thinking about that partnership, and that's on our side too, as the lawyers, of coming to the table as a partner, like Erik mentioned, getting the information we need. So we're not saying no. I'm looking at the Slack channel, and there's a comment of lawyers are always like, well, it depends. And it depends on all of the information. And sometimes we need the information. It's our job to come to the table and ask the questions, but then your job to meet us at the table and provide the answers. And I think the more that we have specialized classes for lawyers and we're teaching each other, what do you need to know? And you're teaching us and all of that, it's just going to get better and better. I know Jerich's a huge advocate of lawyers and CISOs and cybersecurity pros working together, and things like this is how we all learn, how we keep working together.
You know what? Let's talk about how we can work together in a practical sense. There's this concept of legal privilege. I'm going to ask one of you guys to define it, and then we're going to go into explaining why it's needed during and after a cyber attack. Since you're already on camera, Whitney, we'll go with you. If you could define legal privilege, that would be really helpful.
I mean, Kevin's the professor, but So the concept of legal privilege is we as lawyers are the gatekeepers of information for our clients, and communication between lawyers and their clients. In certain circumstances, it's really in anticipation of litigation, but a lot of things are in anticipation of litigation. That's protected by privilege. It cannot be disclosed by us. There's, of course, exceptions for safety, things like that. But for the most part, we cannot disclose communications, only our clients can. And our clients, in most cases, are businesses, but in a number of cases, individuals. But in the context of cybersecurity, our clients are our businesses. The purposes of that is you need to be able to get legal advice without being worried that confidential information is going to come out, and you need legal defense based on that information. It's really sacred, it's really valuable, and it's very important.
All right, I'm gonna park here for a little bit because when I first learned this, it was profound. For others, it may be a duh moment, but I'm gonna go with you, Erik. Explain why this legal privilege is necessary after a cyber attack. And then Kevin, I'm gonna let you explain how we actually get legal privilege after a cyber attack.
Sure. And Whitney hit the nail on the head when she said in anticipation of litigation, because just open up the newspaper or following any attack within days, if not hours, you will see a lawsuit filed against the entity that has been hit by sophisticated plaintiffs' counsel seeking to recover damages on behalf of very often a class of aggrieved consumers. And one of the first, if not the first things they're going to be seeking once they survive a motion to dismiss, or even before it, is what we call discovery. And discovery is simply gathering of information that's relevant in helping them prove their cause of action against the defendant company, usually one that's been breached. And your communications following that incident or during that incident, as you're responding to it, if they are not privileged, they are going to be a roadmap for everything that may have gone wrong. And that's going to be exhibit 1 in front of the jury or on summary judgment before a judge, before it even gets to a jury, to help them prove their case. So the more communications, the more, and this is just the practical meat of it, right? Why we cling to that privilege, besides for the benefits that Whitney pointed out, which is that it allows lawyers to give legal advice and for clients to ask for legal advice without fear that it's going to be on the front page of the Wall Street Journal. You don't want to give an outline, a roadmap to your litigation adversary as to what was happening in the heat of the moment. That's not saying that they won't eventually get that information, but at least initially, you will have an argument to make that these communications are privileged if you follow certain specific steps that we can get into, because it's not just you copy the lawyer on an email and it magically becomes privileged. There are methodical steps that need to be taken.
We're going to get to those steps with Kevin, but let me decrypt
Sure.
what you said, because you spoke like a lawyer, and that's to be expected. What he's really saying here, guys, is if a cyber attack occurs and you call your external counsel, you want everything that you say to them to be privileged and not be able to be shared in court. You don't want the other party that is pressing charges to be able to say, give us all of the interactions with the lawyer, because those interactions are going to include risk decisions that were made, years ago. It's going to include every single vulnerability. It's going to include every single known risk. That never needs to be in the public domain. No matter what the cyber attack is, there are specific reasons for it, and maybe that information needs to be part of it, but decisions that were made that have nothing to do with it don't belong in court, and you creating privilege with your lawyer allows you to protect that information. And this is how you protect yourselves and your organizations when the ensuing cyber attack occurs. Not cyber attack, when the ensuing lawsuit occurs. Lawsuits follow cyber attacks almost all the time, especially if you are in a consumer organization.
Yeah.
And so you want to be able to maintain that privilege. So let's talk about how you maintain that privilege. Kevin, what do you do next?
Yeah, and first off, a clarification point too. Not everything you say to a lawyer is attorney-client privilege. So for instance, an incident response plan or a vulnerability management plan, just because the lawyer helped you build it doesn't mean that's attorney-client privilege. It's more likely, and as long as you mark it so, is business confidential proprietary information, because every type of incident response plan, any management program you build is unique to your own business. So that protection is there. It doesn't mean just because a lawyer said, hey, that looks great, and they helped you build it, that doesn't make it attorney-client privilege. But how do you get that privilege and maintain it is pretty much what Erik and Whitney talked about. You want to make sure that when you're talking to the lawyer, it deals with legal matters and it's an anticipation of a lawsuit. So if you're hit with a data breach, you're already in action there. There's lawsuits and regulatory enforcement actions coming after you, possible criminal. Then you could be a plaintiff in an action too, going after the insurance company trying to get reimbursement. So there's a lot going on there. But key to it is making sure, and Erik touched upon this, is that, everything's attorney-client privilege. So you're sharing with everyone in the business unit. Everyone has, a play to that. That's not what you want. You want to make sure the lawyer's present and it's a handful of people who are getting this information, and it's cloaked, it's small, it's secure, and you're treating it has private and privileged, right? You're not sharing with everyone. And I think, attorney-client privilege, very important, but I think the most important thing here, practically speaking, working with your lawyers before you even get there. That's when you start building out your cybersecurity program, your data privacy program, working in tandem with them and having those muscle memories that when something happens, to call the lawyer. Like you said, you're having that conversation with the lawyer, and that's cloaked right there, right? And then you know how to communicate, and you know how others in the room need to communicate with your lawyers as well. And it is very important because, as Erik mentioned, I like how I put that. Once you get over the motion to dismiss and the way things are going, you're probably not going to, you're going to lose on that one. Once you're in litigation, you want to make sure things aren't out in the public realm, and you're making sure your adversaries don't have that to use that against you, because you're having candid conversations to protect your business.
Yeah, I'll give some practical examples. The forensics investigation report that comes out of your forensics investigator, that should be in very few hands. If you send it to 20, 30 people in the organization, you've now potentially lost the right to call it confidential because you're sharing it with other people, right? And thus, that's one of the reasons why we keep that information tight. There's one more step that I didn't hear you guys say, and let me know if you disagree, and Whitney, please jump in here. When you want to reach out to external counsel, your legal team should do it, not your cyber team. Maybe you can explain why, Whitney.
And that's the same. It's not just external counsel, but it's any external provider. So your forensic investigator, which is, it's an awkward thing because the security team has the relationship with the forensic provider. But this is because there are court decisions now that have said, hey, they're looking at, was this person brought in for this investigation, or are they just a standard member of the team? And is it special enough, this investigation being done, or is it just standard business practice? And so what you want if you're doing an investigation that you're worried about litigation for, which is most of them, is you want to have the interactions rise to the level of, this is special, it's not a standard business interaction. And so that's why you want the lawyer to reach out to external counsel. They're getting engaged by legal. And the same thing, and this is the strange thing, the same thing for the forensic investigation firm. So if you already have one that you've got an agreement with, and you just reach out and say, let's start another SOW, let's do a new forensic report for this investigation. And they're like, okay, let's get engaged. That's likely going to be discoverable because that's seen as a normal business practice. You want it to be done in anticipation of litigation. So you want either internal, preferably external. Sometimes it'll take a couple of days for external and you can't wait that long. So have internal lawyers reach out and engage the firm and say, we've had an incident, we need you to come in. Even better, but this is even harder to do, is to have a totally different forensic investigation firm. To do that though, you want to have just one on deck and ready to go that you've already interviewed, screened, engaged, and you say, you are our firm for investigations and we will call you if there's an investigation. That way you're not.
I want to echo what Whitney's. Yeah, go ahead, Kevin. No, I was just going to echo what Whitney said. I mean, that she's right. That is the ideal situation where you have preset external counsel who is going to be the one that engages that specialized, dedicated forensic firm that's coming on for that purpose, so that you can say to the court, this was brought on after this incident. They're not our standard go-to firm for providing advice, regular business advice. They were brought on for this specific legal purpose, and they were retained by counsel. And all this does is emphasize the importance of having those relationships in advance, having those discussions in advance. I joke all the time on panels like this. I am the floor warden for our building for fires, and they give us a little packet that's got all the phone numbers and procedures. You should have if an emergency break glass paper sheet that lists all this out. It lists who's the go-to external counsel. It lists who the go-to external forensic and technical consultant, because you may not have access to your systems when the fire starts, and you want that in the right hands and in the right format so it's accessible and usable and user friendly.
Yeah, I completely agree with you. And let me put this in terms that some of the people out there may understand. Let's say you bring Mandiant in. They are like one of the companies that a lot of people call when there's a breach. If you have them come on an annual basis to do a pen test, to do a breach readiness, to do a breach analysis, and then shortly after you extend that engagement because you think there may be a cyber attack, that is when that information kind of gets conflated together. There need to be two completely different statements of work, and ideally two different companies to make it even clearer, but for sure two different statements of work. So the other lawyer can't claim, oh, this is just something that they do annually, so we can get that information. They need to have complete clarity and confidence that they were brought in specifically for the potential incident at hand in respect to potential litigation. I think that's what you're saying.
Just to Kevin's point earlier about different size organizations, I mean, what Whitney and I are referring to is the ideal setup for, you know, a large organization like a Cap One. There are much smaller entities, and you do the best you can, and you tailor a solution that's appropriate for your size and type of organization.
Spot on. All right, so we're talking about cyber attacks a little bit, and one of you brought up tabletops earlier. So let's talk about that a little bit. One, if you bring the lawyers in to your tabletops, is that privileged? And two, I'm just curious, do you guys even get offered opportunities to sit in tabletops, and what does that look like? Let's start with you, Kevin.
Sure. I'm on the board of directors for a couple of companies, so I've sat in tabletop exercises, which have been, very, fun to go through. And as a professor who teaches incident response, it's great to see how that plays out. You get to see the good, the bad, the ugly. So that's one. Two, on the privilege piece, that depends, right? Because you could argue and say like, hey, we're doing these tabletops. This is anticipation of litigation and things along those lines. But what litigation? Because you can make the argument of like, well, we're told by the government it's not a matter of if, it's a matter of when. So there's going to be litigation because we're going to be the victim of a cyber attack. So we're preparing accordingly. So I'd say maybe, but I don't think that's why you're doing a tabletop exercise. You're doing the tabletop exercise to see where you are, and anyone out there. If you got punched in the face today with a ransomware attack, what are you going to do? And if the answer is we don't know, well, that's problematic. And that's why you have these tabletop exercises. It's a great way to see where you are in the process. And then really it's the hot wash afterwards, like what worked, what didn't work, and what do we need to do to get better? And from the tabletop exercises, I've been at the crawl stage, where it's really, we're not here to scare anyone. And I like those because they're very methodical and people are learning what's going on. And then if you've ever been to the IBM cyber range, that's where they scare everyone, and it's crazy. It's great exercise, and it's a great way for CISOs, anyone like that, to bring your board of directors, because you'll get a lot of money from that one after that. That's my practical advice.
Yeah, no, I've done that. What about you, Whitney? Have you been invited to any tabletops with your customers?
In-house, but as external counsel, we would more lead them. But external counsel doesn't have to and shouldn't necessarily lead them. I think your question is, should lawyers be at tabletops? Absolutely. Everyone should be at a tabletop who will be involved in an incident. And so you're gonna want board members, executives, lawyers. You want the people that will be in the room. And so sometimes you'll have a data protection or cybersecurity lawyer at the company, but the actual lawyer in the room is going to be the general counsel, most likely. So you want to toss that general counsel in there and see in the moment, are they ready? What do they need to be prepped on? And that way, if there's a data protection lawyer, they can prep the general counsel and know I'm going to be on deck. It's very much, you want to get all of the adrenaline and awkwardness out so everyone knows, what am I going to be faced with in the moment and have to make quick decisions on, and be ready with all those scenarios. Are you going to pay, like if you're asked for Bitcoin, are you going to pay it? If so, how? Are you going to try to find one of those Bitcoin ATMs or use a third-party provider? Or is the board going to say, no way, no how? You want to have those conversations when you have the benefit of time. And does the lawyer need to research any regulations about payment of Bitcoin? And are you going to have to do those reporting obligations to your shareholders? all those questions are going to come out in the moment and you want it to be the practice.
Yeah, I agree with you. I think going back to when tabletops first were introduced to me, they've matured as the ascension of the CISO has matured. Before it was get the technical people in the room. Do you know what to do? Can you detect this alert? Would you know who to send the next set of responses to? Do you have the proper processes to contain? Do you have all these things? And we would always focus on the technical aspects of what could happen. Are we ready? And then we started to expand into communications. Okay, do we know how we would communicate? Do we know who we would communicate to? And how would we do internal communications? How would we do external communications? And now we're starting to see the board and lawyers and all the other people that play a part, your PR teams. I mean, the list goes on, all need to be at the table because quite frankly, they're going to be at the table when the real thing occurs, and the real thing is going to occur at some point. So you want to build that muscle memory. I always say that CISOs are like tea bags. You never know what's in them until they're in hot water. I think our lawyers are the same way, right? You don't know how your lawyer is going to really respond when they have to handle that 2:30 a.m. call because they haven't been built to deal with the 2:30 a.m. call. The security teams have, specifically on Friday nights or on holidays, right? So this is definitely something that I fully agree with you. The lawyers should be heavily involved in. So let's pivot some more. And we talk about lawyers from a responsive perspective. What is your stance on legal being involved in proactive activities and helping prepare for the things that are occurred? Not necessarily tabletops, but any other things that we do from a cyber perspective in a proactive manner.
Yeah, I'll jump in on that one, Jerry. I mean, I think just as we discussed with the tabletops, the more that we can be involved early on, the more we can think out and spot issues and try to come up with solutions in advance. Again, we mentioned just reviewing contracts in advance and knowing and advising on obligations that we are taking on, that we are imposing on others, looking out for regulatory hotspots, and just mitigating risk in general, and being part of the team and being seen as, again, part of the solution, a partner, rather than an obstacle on the transactional side of things, and someone to hide something from in the event of an emergency and litigation front.
Awesome. Someone else have any other thoughts?
Yeah, my thoughts. I think you need the lawyers, highly involved, especially internal counsel. Okay, and building out your cybersecurity program, your data privacy program. Because there's so much to it. So you have to have that whole crosswalk on the regulatory requirements. So it might be one standard applies here and a different one here. And how do you match all that up? And I think that's really important because you don't see that as much as you should. And when there's a data breach and the regulators come in, you won't see that matchup. And I think to stop that, it's real, and it's a great way to do it. You look at what your program is. Many start with NIST now. A lot of the regulations are really coming out. They're not saying NIST, but they're telling you to identify, detect, protect, respond, recover. Okay, great. So you look at what those requirements are, and then start matching up. And as you build your program, you're doing that crosswalk. And with the lawyers involved, you're protecting yourself when, like you said, it happens. The regulators come in after the fact to look like, oh, what you did, and they're just attacking your cyber program. No matter what you did and how strong it is, they're going to try to tear it down. You want to be able to counter and say, this is why we did this. This is how we matched up. This is how this regulation matched up as well. So I think it's really important, especially have internal counsel work together, because it will benefit the organization in the end.
I love it. And I'll add that every CISO has been asked the question, hey, this organization got breached, can that happen to us? We've all been asked that question. There's a new question that's being asked. This thing happened to Joe Sullivan, can that happen to us? This insurance thing just happened, can that happen to us? This lawsuit just occurred, can that happen to us? And the lawyers have to answer that question. Even though it's cyber related, CISOs can't answer that question. We're not equipped, we're not skilled enough. And quite frankly, we would be speaking in legalese and it would sound like broken legalese. So we need you guys to be at the table for that. And I think that's a very much so a proactive activity. Someone was nodding their head, I can't remember who, but I don't know if you guys have thoughts on that.
Yeah, there was very vigorous nodding from that. Yeah, I think that the proactive planning for me, and I think for so many data protection lawyers, that's our favorite stuff. Because you're anticipating what can go wrong, how you're building your fort. And on the legal side, our job right now in this landscape of changing laws and technology that is so incredible, like it is mind-boggling how the technology has outpaced the law. We are looking at laws that say things like reasonable security measures, and then interpretations of security programs after the fact by government agencies saying that wasn't good enough. And then companies struggling to say, well, how do I make it good enough? And so we're bringing in the let's build a program to protect legal risk, but working with you to say, okay, what are the options out there? And you're like, well, we can build the strongest fort ever, but it's going to be incredibly expensive and no one will be able to access the data without two phones and doing a rain dance and then jumping on their head, but then they can get in the system. So we do that balance. And a lot of it feels like you're kind of crossing your fingers and hoping for the best, but you're doing that with an informed side. And so our informed side is we understand the legal landscape and what the regulators are looking at and saying, hey, like you need two-factor authentication when the risk of data is XYZ, or your systems were not strong enough and you didn't have MDM for BYOD in 2011, when you clearly should have. We're taking all these little pieces and then bringing it to conversations now saying, okay, we could create a risk. This is what the risk could be. Is that something we want to accept? Or how strong do we want to make it? And it's very much an inflow conversation. You want to document things as much as possible because the reality is you're going to be looking back saying, why did we do that?
Mm-hmm. Whitney, you were a breath of fresh air. As you know, this is why we worked well together. I'm so used to lawyers being black and white. This is legal, this is not legal. And you use the word risk, and that's the word we use in security. So I'm loving seeing that conversation moving towards risk. I want to get to the hottest topic. This is the sexy topic of the day, artificial intelligence, right? And there are legal implications of such. What role do you guys see AI playing in the future of the courtroom? And I'll give each one of you an opportunity to kind of share your thoughts, and we'll start with you, Kevin, since you seem eager to speak just now.
Well, we just had this conversation last week over at MIT on a panel on artificial intelligence. And it's funny how you said, like, where do I see it in the courtroom? I don't see it in the courtroom, really. I mean, artificial intelligence, I think on the legal scheme of things, as it impacts lawyers, I think it will just make us more efficient. I don't think it's going to be the end of lawyers or accountants or newspaper writers or anything like that. It's like, what we see right now, if you're just focusing on ChatGPT, it's more of a really fast search engine and give you some material that you'll have to vet out, and it will help you as you do your research or your writing or things along those lines. It will make you more efficient, okay? Which will be great for the customers or your clients because it will be a little cheaper for them, right? Because the ChatGPT is going to pull a lot of time there, but you're always going to have the lawyers there. As far as like the cybersecurity, your side, there's a different, it's really the machine learning aspect of it. It's going to make your job better in one way, it'll be quicker, looking at, I think for the cyber analyst, instead of having 10, you might have 8. That's what will happen. It will just make jobs more efficient. I don't think it's going to be, a robot going into court and then a judge who's an AI making the decisions, because we're just not going to let that happen. And already regulations prevent that anyways.
So to clarify my question, I more so mean, how do you see evidence being impacted by AI? Meaning, can you trust the source or all the other things that I probably couldn't even imagine?
I think it's the same. It's going to be used as a tool, but ultimately you're going to have a human eye on it.
Makes sense. Erik, what are your thoughts?
Yeah, no, I would agree with that. In full disclosure, I sit on the advisory board of an AI discovery company, but I see it in that context that Kevin mentioned, bringing efficiencies, but you're ultimately going to have a human set of eyes look at the evidence that the AI has discerned from a gazillion terabytes of data that it's plowed through to find the answer. We're discussing it all the time. A lot of the cases that I deal with and others deal with have thousands, if not tens of thousands of individuals involved in them, and can AI play a role in fostering communications with all of those parties and interests, and that may be another application. I don't think we're quite there yet, but it also may play a role within our organizations in promoting good cyber hygiene. I'm just thinking back to what we were discussing on the previous question. How do the lawyers get involved? It's how do the lawyers get involved? How do the CISOs get involved? It's how do we make cybersecurity and privacy integral parts of what everybody at an organization is doing, not just guarding against intrusions, but in terms of whether they're building products, designing services, or contemplating business transactions. I mean, one of the things that we talk about all the time at our firm is cyber due diligence. What digital assets are we inheriting, purchasing, whatever, that can have ticking time bombs in terms of dangerous data inside of them? And so the more we raise people's awareness of these issues, bring in the lawyers, bring in the CISOs early in that process, the better we're able to identify and work through those challenges.
Thank you, Erik and Whitney.
And Jerich, I'm gonna touch on the scary thing that I think that you were getting at with evidence in the courtroom, which is the deep fakes, which you and I discussed with the late Ben Wright on the Cyberside Chats podcast. But the reality, the reality that the use of AI tools is going to make evidence faking it's astronomical. We've seen it already. We've seen so much on Twitter with Trump getting fake arrested and deep fake voices and videos, and the creation of evidence it's already frightening. And I think the hope and the silver lining is that the ability to create these tools that can do wonderful and scary things also comes with the ability to create tools that can hopefully detect the source of the information. And so I think what we're going to be seeing a lot more of is chain of evidence. And that's already something that's in the courtroom. You need to show where the evidence came from. It's just less technical, but I think something like, blockchain transactions or something showing creation of information and the metadata behind the information is going to be very, very standard.
Thank you. I was at first wondering if this was going to be the most boring response to AI that I've ever heard. And you probably made it a little bit more spicy, but I agree with everything you guys said. Depends on what perspective you look at it as. That being said, ending it with chain of evidence, we call it chain of custody in cybersecurity. I think that's what's really going to be paramount. At the end of the day, can you trust the source? And what mechanisms do we have in place to trust the source? And has the source information been altered by the time it's gotten to you? That's incident response 101 when we're having to go in front of a courtroom. I think it's going to be no different here. All right, we have a ton of questions that have come in, and I've asked people to prioritize them. So whichever ones have the most likes, y'all, I'm going to start asking. So I'm going to start with the one that has 4 likes. Please feel free to jump into the chat and start adding more likes or questions. So the first question is, we have cybersecurity insurance. Is the information we share with them privileged? They are responsible for hiring forensics and outside counsel. Who wants to answer that one?
Yeah.
All right, I'll pick on one of you. Erik.
You don't want the depends answer. You are, if they are paying for your counsel and you're selecting them from the panel, they are still your counsel, and the information that you are sharing with your counsel is privileged, assuming all of the other conditions that we talked about previously. But not all of that information. If you're in a coverage dispute with them, they are going to be in an adversarial position with you. Am I cut out? I just saw some free. Okay.
I got you.
Yeah, so you have to be mindful, especially if there's a potential for a coverage dispute, that everything may not be privileged. And what I always advise people is insurance policies are dense, complex documents. You need to have somebody that knows how to read them, read it before you enroll and pay your premiums. And as it gets amended along the way, make sure you understand those amendments, because it can touch upon exactly what we're talking about here, which is whether the privilege holds in in discussions with the insurance company.
All right, thank you for that. Another question that's come in is, what is the best way to approach counsel when the cybersecurity team wants to put in a specific detailed policy, but legal wants to be a little bit more vague? I'm gonna go with you, Whitney, because you smirked.
Bring chocolate is what I like to say. I think come to the table with an open mind and understanding. I think you're going to be compromising in between. The reason you want details is because that's your job. You like the details and you want prescription. The reason the lawyers don't want the detail is because if you don't follow the details in your own policy and you're held to be in violation of your own policy, that's a problem. So we like the policies to be vague but specific for that reason, because it's our job to say, hey, I don't want a policy where we're not always going to follow it. We want you to have flexibility. And so sometimes we might say, hey, let's do a policy and then let's have like a guide where there's different scenarios. That's a little more flexible and you can update it more regularly and things like that. And so that's often the balance. But where you can push back is say, no, we need to hold ourselves to this standard and we absolutely should follow it. And if we don't have it in the policy, people will not follow it. That's how you come to the table and counteract that.
Thank you, thank you. We have time for one more question. So I'll make this one generic. Maybe all of you guys can weigh in on this one. What are some practical tips and tactics to increase collaboration between InfoSec and legal, let's say in a larger organization? I'm gonna go left to right, and for me, that means you, Erik, Whitney, and then Kevin. So, Erik.
Yeah, I mean, I think it's when everybody has a better understanding of everybody else's role and where they're coming from. Example like Whitney just gave us as to why lawyers want to build in flexibility and more technical folks may want more precision. It helps to build that trust and build that team aspect.
Thank you, Erik. Whitney.
And when possible, treat the lawyer as your team member. Do like a monthly check-in where you're like, hey, here's what's going on. Give access to the lawyers by your team members. So other team members can call the lawyers, they get to know them. If you have like a, quarterly dinner or whatever, have the lawyer come. So you're just getting to know each other like colleagues. And then when issues come up, and that's how I found it. When issues come up, someone would send me a chat or they'd call me and be like, oh, hey, Whitney, this came up. Should I tell you about this? And I could be like, oh, no, I don't need to know about things like that. What I do need to know is X, Y, Z. And so just the more, we're people, you treat each other like people and like colleagues.
I love that response. I always say, don't create a relationship when you need it. Create it before you need it, number one. And for my lawyers and a few other stakeholders, if you're not on an instant message or text message level communication with them, your relationship isn't good enough. Simple as that. Now, granted, some of the lawyers do not like these little fidgety things on their phones and so forth, but they have ways of communicating that are beyond just email. If you're not in that group of people that get to do that, your relationship isn't strong enough. Kevin.
Yeah, mine was really basic. Go knock on their door and ask them if they want a cup of coffee. Buy them a cup of coffee. It's all personal, right? Everything's personal. You build a personal relationship, that business relationship's going to thrive. So I think you covered the bases on all of that.
Love it, love it. Thank you guys for taking the time. I want to end this with a final tribute to the late Ben Wright. He founded the first cybersecurity course, I think ever, but for sure within SANS on legal, was the only person to teach that course and offer that course for many, many, many years. He passed away late last year. And this conversation and many of the legal cybersecurity conversations that are being had in many part are because of his pioneering and his vision of seeing the intersection between cybersecurity and legal. So to the great Ben Wright, thank you for your contributions. And for everybody else, thank you guys for joining.
Thank you.
Thank you, everyone.
Thank you, Erik.